Hello and welcome to another presentation. In this presentation I'm going to go over what is known as a Notice of Liability. I've received many questions and concerns regarding a Notice of Liability and how to enforce it. So today I'm going to go over what a Notice of Liability is and how it is done. And then we will discuss the legal ramifications for doing so and take it from there. In short, a notice of liability is a statement of facts and is the basis for a claim. The purpose is to take a course of action that may lead to an immediate remedy against an individual, not a corporation, entity or institution, or business. The goal is to go after the person directly, causing the harm to have the biggest impact. The concept is that the folks that get these notices of liability will not want to take on the risk of the liability. The problem, however, with the notice of liability is it's not really a legal document. It's not enforceable in and of itself. You would need to take your claim to a higher court or to a court. Now, my way of thinking is, if you're going to take somebody to court for something, why would I want to send them a notice of liability and warn them that there's a potential problem? And many people go through a three-step process, three-notice process, and then they come to the end of it and they say, okay, now how do I enforce it? And unfortunately, I have to tell them they have to go all the way back to the start and file the statement of claim in the proper court venue. So in essence, the notice of liability was a waste of time. At least that's how it applies in Canada. Now, if you're in the UK, they have a different protocol called a pre-action protocol. And the notice of liability can be modified to conform to this pre-action protocol, which is a requirement in a civil claim within a UK court. Your claim, if I recall correctly, files on a form N1, but you can do all this pre-action protocol in advance. But please be sure that you follow all of the requirements within the UK if you're intending to use it in that application. As far as being in Ontario or being in Canada, this notice of liability really has no force and effect, other than you can say you tried to resolve it, and you can use it as ammunition, saying that you were trying to resolve the issue prior to bringing a claim into court. That's the only purpose that it has. In and of itself, it is not enforceable. Now, if we talk about small claims court, where many people would like to take their claim, the max that you can claim in small claims court currently is $35,000. This is for Ontario. Please check with your province if you're operating outside of Ontario. This is the advantage. If someone doesn't have a lot of money, the court costs and filing fees and that are more reasonable than if you go to a superior court. And in some cases, the cost may be free if you're a low-income person. Okay, legal fees are very low, at usually 15% of what you're asking for. Now, you could also put what you're asking for as part of your claim, and that would alleviate that problem. You do not need to be a registered business or entity to claim monies owed from an individual. And that's applicable whether it's in small claims court or in a standard court, which is a superior court in Ontario. The same thing would apply in any other province. Now, in the UK, we don't have a small claims court. The notice of liability contains 5 parts: statement of facts, whatever harm they've caused you, whatever laws they've broken, and then you typically give them time to make an adjustment or make a correction in the hopes that you won't have to take them into a higher court, and you provide them the remedy that you're seeking. In essence, what you're trying to do is you're trying to settle this matter privately. That's all the notice of liability does. If you can't resolve it privately, you will have to take this into a higher court or to a real court in order to get a remedy. And so all this is you are supposed to try to mediate, which is have a meeting basically, before you litigate. Mediate before litigate is well understood, or should be well understood, from anybody that's practicing law, And by that I mean any lawyer. I don't classify what I do as practicing law. I quote the law for what it is. Now, many people have tried this process of the notice of liability, and then they get to the end of it and they say, well, how do I enforce it? And as I said earlier, the only way to enforce it is to use it as evidence to say you're trying to resolve your issue before you file something into a higher court. You can't enforce this directly on its own. Well, when you do this notice of liability, it's the same as doing a statement of claim. So my way of thinking is you might just as well do a statement of claim. However, the statement of claim is basically a story, a statement of facts, and that's the first thing that you do. The statement of facts pertains to the violation of your rights. You will typically state who you are and the circumstances surrounding the event, like what you were doing or what they were doing. And then in part B of that, you will state how your rights were infringed, and you don't have to go into great detail, but make it every paragraph should be one point, and every point should be as succinct as possible in order to allow the judge or mediator to fully comprehend in the shortest time possible whatever point you're trying to make within that paragraph. And you typically have to do all this under an affidavit anyway. So this is why I state you might just as well file a statement of claim and file an affidavit in support of that statement of claim, which is part of your standard civil court procedures, whether you're in Canada, province of Ontario, or the United Kingdom, or even the United States, or Australia, or anywhere else for that matter in the world. The second thing that you do is you outline what harm is done, what violation of rights that they've done, what they've done against your consent or your right to privacy, whether they've assaulted you or attempted to assault you, and any loss that you may have suffered, including education or employment, which is considered to be a necessity of life, or physiological harm done by discrimination and segregation. If they keep you out of school, say, entirely, that would be one thing. Or if they tell you you can't show up for work because you are subject to undergo a medical intervention, that's not permitted under the law. No one can force you to take a medical procedure against your will. Many people have tried to use this NOL process and come to the end of the line and still can't enforce it. The next thing they do is what you should do is you should quote the legal basis for your claim, based on a breach of an oath or a common law fundamental right, any violation of a civil or criminal code, and at that time you can also reference court cases from higher courts, and the lower courts are obligated to follow the higher courts. Then what you do is you give them a chance to respond. And typically the minimum is 7 days, but I would typically give them 21 days to answer, or possibly 30 days to answer. And when they don't, then you would follow up with a notice of default, which is basically a reminder notice. And then you would follow up that with a final notice, and then it would be default judgment. But you can't enforce any of this, so like I said earlier, you might just as well, once you've given them the 3 notices, turn around and use that as evidence in a court of law and start filing a civil claim. You also, when you write up these claims, you would provide whatever remedy that you want. It might be compensation for, harm, injury, cost of repairs, cost of loss of income, if you were put on, mandatory leave, something like that. The standard amount courts will award for violation of a right is $5,000, but if you take it to a higher court, that could be quite a bit higher. Okay, and what I would typically suggest people do is look at other court cases that have been filed through a proper court, not this NOL process, and see how what they get awarded for costs based on similar circumstances. That way you're not under, what is classified as the norm and shortchanging yourself, and at the same time you're not way over, and there's no chance in heck that you will ever get a remedy. I see a lot of people turning around and writing up a fee. They call it a fee schedule, and it's something like $5,000 a minute, which is completely unrealistic, and there's no way that a judge would ever award that to you, because it's not realistic. If you think of a standard lawyer getting paid somewhere between $350 and $500 an hour, how can you come along and say you're going to charge $3,000 a minute? The judge will just laugh at you, or he'll tell you that this is frivolous and vexatious and throw it out. So, in summary, although I see the NOL process as a first step in trying to resolve an issue outside of the court, it really has no basis and no way to enforce it until you bring it into a court. And as I said earlier in this presentation, if I was going to take somebody to court for a specific reason, you might want to turn around and do this notice of liability, tell them where they're breaking the law. But if they are, of the mindset that they're going to continue to do this, then there's no point in wasting your time and informing them that something bad is coming down the line. You might just as well file a proper statement of claim, and you can always file a discontinuance and withdraw your claim from the court. The only downside is that you will have paid your court fee to initiate your claim, and you won't be getting that back unless you get a judgment in your favor. And if you do settle it out of court, you will likely not be getting that fee back again. So it's entirely up to the individual. However, I see many people going through this NOL process, filing letter after letter after letter. In some cases, what happens is the individual at the other end gets this notice of liability, and all they do is change positions, change offices, move to a different department. And then you have to start this process all over again with the new party, and so it really serves no function. I hope this information was helpful. If you have any other topics you would like me to cover, please send me an email with the topic, and if you'd like to be added to the mailing list, you can send me an email to the address shown on the screen. I do not share your emails. I do not spam your mailbox. If something new comes out, or you've asked questions, or there's a general need for an answer or a request, I will send you an email. It might be once every 3 months, something like that. Now, I was trying to coordinate a presentation series both within Canada and Canada and the UK, and so far there's interest only in one specific town that's willing to coordinate it, and that's even a maybe. So if we don't get some action as far as people wanting these presentations the first part of December, I will be releasing books on various topics, and I'll keep the people of the group informed of these publications, one of which is on council tax, one of which is on asset protection, but there's a number of them. And so I will just make basically a book announcement video, and those that are interested can follow the link, which will be done through Amazon. I thank you for listening to this presentation. I hope you found it useful, and I look forward to bringing you additional information as the need and time permits. Thank you, and have a good night.